see Judge Day.
A week from Thursday. A week from today.
That would be the 22nd of January.
That works for the state, Your Honor.
Thank you, Ms. Hunt. I apologize. I should have asked you, Ms. Ortega. Then 1 o'clock on January 15th in front of Judge Day. Okay, thank you very much.
Thank you, Your Honor.
To this issue, this is not a situation, State of Utah versus Brianne Altice, case number 1317020.
Susan Hunt, attorney for the state.
Okay, what is the defendant's reason for entering the plea?
Exactly the same reason.
Okay.
It's to resolve a case that would have none recited from 2015 will be dismissed with prejudice, and the preceding information would be dismissed.
Have some issues trying these cases all separately, and we feel that that this resolution does meet the needs of justice, but also lets us still
Use also a second-degree felony. How do you plead?
guilty.
And finally, count 3 plea in case number 131702004 will be dismissed as we're in custody until the date of sentencing.
Altice pleaded guilty to having sexual relationships with 3 different students, then focus on her children.
Was released. They determined.
Okay.
Look at the defendant's conduct in connection to these 3.
It relates, to this issue. This is not a situation where I think the issue is clear. It's what is a teacher. I think the issue of what is a teacher isn't so much a legal issue as it's a factual issue. And is a person a teacher when they have a student in a class, or is a person a teacher after? And I'm going to deny the motion to dismiss for these reasons. First, I do not believe, I think the teacher, whether a person's a teacher and holds that position of special trust is a factual issue. And I believe that there's evidence to support that from the preliminary hearing. I would also rule, though, that in the statute that defines a position of special trust, it lists all of the individuals, including the teacher, but at the end it says any person in a position of authority which enables the person to exercise undue influence. And even if somebody's not considered a teacher after somebody leaves their class, I think there's evidence to support in the preliminary hearing that she was a person in a position of authority which enabled her to do that. So for that reason, I will not dismiss or quash count 10 of case number 1. Defendant's arguments, they raised 2 arguments for the suppression of the defendant's statements made while interviewed by officers on October 28th of 2013. First, defendant argues that she never affirmatively waived her Miranda rights and that her statements to the officers were made as a result of police coercion. Defendant then stated she was confused and didn't understand. These statements again appear to relate to defendant's lack of understanding as to why the officers were there, not a lack of understanding of her rights. At this point, Detective Olson indicated that there was a student at Davis High School and asked her if she had any favorite students or if anyone in the school was acting suspicious lately. The defendant responded that a student had told his girlfriend that he and defendant, quote, had done stuff together, close quote. For the first time, defendant stated, "I don't even know what my rights are at this time. I know you read my Miranda rights to me, but I don't." Detective Olson immediately asked defendant if she wanted to remind her of her Miranda rights, to which defendant replied, "No." The court finds that the state has met its burden to establish that the defendant voluntarily, knowingly, and intelligently waived her Miranda rights when initially speaking with Detective Olson. While the defendant did not affirmatively state that she waived her rights, Her responses to Detective Olson's questions clearly demonstrate that she understood her rights. Therefore, I reject defendant's argument regarding her waiver of rights. The court does not find that the officer's persistence was improperly coercive or that it is suggestive that defendant's statements were involuntary. Regarding police trickery, the court finds that the officers did not lie, exaggerate, or misrepresent the evidence they had against the defendant. The officers were made as a result of police coercion. Defendant then stated she was confused and didn't understand. Brianne Altice, case number 131702004 and 151700044. I'd like to get your appearances for the record.
Raspberry Altice.
Susan had to turn for the state.
Okay, and what is the defendant's reason for entering the plea?
Exactly the same reasons.
Okay.
It's to resolve a case that would have an uncertain outcome if we were to try.
Previously, in case number 131702004 will be dismissed, as well as case 151700044 will be dismissed. Okay, I'm going to just keep her in custody until the date of sentencing. How do you plead?
Guilty.
And finally, count 3, forcible sexual abuse, second-degree felony. How do you plead?
Guilty. The defendant was placed into custody after charges were filed alleging that she had continued to engage in a sexual relationship with one.
These two cases, she's really interactive.
Sexual activity with a minor, all three are third-degree felonies. How do you plead? And count of dealing in materials harmful to a minor, also third-degree felony. How do you plead?
In a fair way.
To this issue, this is not a situation where I think the issue is clear. It's what is a teacher. I think the issue of what is a teacher isn't so much a legal issue as it's a factual issue. And is a person a teacher when they have a student coercive, or that it is suggestive that defendant's statements were involuntary? Regarding police trickery, the court finds that the officers did not lie, exaggerate, or misrepresent the evidence they had against.
Brianne Altice appeared in court in Bountiful again on Monday, March 30th. The former Davis High School teacher has been charged with having sexual relationships with 3 underage students.
Are denied, and that the other bad acts evidence.
Lawyers for both sides will be meeting again to schedule further hearings in April. Brianne Altice appeared in court in Bountiful again on Monday, March 30th. The former Davis High School teacher has been charged with having sexual relationships with 3 underage students.
All of them trusted her.
14 felony charges, in part rape and unlawful sexual activity with a minor. Now, a scheduling conference was also put on the books today.
Are denied, and that the other bad acts evidence.
Lawyers for both sides will be meeting again to schedule further hearings in April.
Made as a result of police coercion. Lie, exaggerate, or misrepresent the evidence they had against.